Good morning, everybody. A happy old new year. This is our first meeting in 2014 of the Rural Affairs, Climate Change and Environment Committee. I know we're already a few weeks into it, but I hope that everyone's had a good break over the festive period. On behalf of the committee, I welcome you all back. Members and the public, turn off your telephones and they can affect the sound system. Agenda item 1, subordinate legislation. And it concerns the Feed Hygiene and Enforcement Animal Feed Scotland Amendment Regulation 2013, SSI 2013/340. We should note there is no motion to annul that's been received. I refer members to the paper. Is the committee agreed that it does not wish to make any recommendations in relation to this instrument? We are agreed. Thank you very much. Yes.
Thanks, Convener. Can I just say that it's encouraging to note that there are no businesses requiring further approval under this legislation, and I'm also pleased to see that all 4 small to medium-sized Scottish firms producing fish oils for animal feeds currently meet the requirements.
Right, that's well worth putting on the record in relation to the realities of this order. Thanks very much. We now move to agenda item 2, the proposed draft Agricultural Holdings Scotland Act 2003 Remedial Order 2014. For our second agenda item today, the committee will take evidence from the Cabinet Secretary for Rural Affairs and the Environment on the proposed draft order. And we welcome the Cabinet Secretary. Good morning, Richard. And his officials, David Balhari, Project Team Leader, ECHR Compliance Order. Good morning. And Paul Caquette, the Deputy Solicitor and Head of Group 2 this morning. So I believe that the Cabinet Secretary wants to make an opening statement, if you will.
Thank you. Thank you very much, Convener, and a belated Happy New Year to the committee as well, given this is my first appearance of 2014, and a special welcome and Happy New Year to Cara Hilton, the new member of the committee, and I just want to welcome you to the committee. This is my first time that I've appeared with you as a member. So we've got a very important topic to discuss today, and I very much welcome the opportunity to say a few words and perhaps use the opportunity to clarify a number of important points before we get the questions and answers underway. Briefly, just turning to the background, the committee will be aware a decade ago the Agricultural Holdings Act 2003 recognised that a new system was needed to offer security of tenure to the tenant and to the landlord and the prospect of recovering vacant possession. The 2003 Act sought to address this issue through the creation of short limited duration tenancies and limited duration tenancies. However, before the arrival of the 2003 Act, the market had, of course, devised limited partnerships in the industry as a means of giving landlords, as they saw it, the confidence that they could recover vacant possession. Limited partnerships, while attractive to landlords, were, of course, seen by many as disadvantageous to existing tenants because of reduced security of tenure and absence of legal cover associated with the normal checks and balances of a secure tenancy. In light of the events during the passage of the bill, the 2003 Act provided a mechanism in legislation for limited partnerships to be brought to an end in a way that respected the needs of the tenants. The solutions, of course, are detailed in sections 72 and 73 of the Act. Section 72 describes the legal process for moving from a limited partnership into the process described in section 73 for bringing a limited partnership to an end at the end, of course, of its contractual period. The process outlined in section 73 provides tenants with a minimum of 2 years' notice and requires the landlord to terminate the tenancy by giving intimation of their intention to do so and then serving the notice to quit. During the passage of the bill, a number of landlords served advance notices on tenants to quit their farms when the limited partnership's contracts expired. As you'll be well aware, many commentators believe that notices may have been served in an attempt to circumvent the possibility that the bill might be amended to bring with it an absolute right to buy. When the legislation, which came into force in June 2003, it included an anti-avoidance provision for any landlord who had served a notice to quit during the period of September 2002 to June 2003. The anti-avoidance measure was that tenants would gain a secure 91 tenancy. On the 24th of April 2013, the Supreme Court concluded that the anti-avoidance described, while not wrong in principle, were contrary to landlords' human rights for being arbitrary and disproportionate. In their judgment, the Supreme Court provided some guidance on the way forward and recognised that the legislation had had an effect since 2003, during which time a number of people who were not parties to the actual court case would have been affected by the ruling nevertheless. Consequently, the Supreme Court provided the Scottish Parliament, guided by ministers, until April this year to consider with the industry solutions that respect the landlord's rights under the European Convention on Human Rights, and then to bring that into effect. In the drafting of the order, we have therefore had to walk a very difficult line, balancing the European Convention on Human Rights requirements of both the tenant and the landlord. The route we have taken, I believe, seeks to provide a remedy which alters only non-compliant ECHR outcomes. In providing for these arrangements to be altered, we have recognised the practicalities of farming and farm businesses that they face and the need for an orderly transition. I also want to use this opportunity to record my appreciation to all stakeholders for their positive engagement in working with their officials to find a solution to what are very, very difficult and very complex issues, as I'm sure the committee has discovered. When the committee took evidence from the stakeholders in December, two issues were highlighted in particular. It may help to make my position clear on these issues in advance of your questions. The two issues are compensation on the one hand and issues relating to the absolute right to buy on the other hand. Firstly, turning to compensation, the purpose of the order is solely to remedy the unlawful legislative outcomes in Section 72, which have resulted from the defect identified in the Supreme Court judgment. I was heartened to hear recognition from stakeholders that it is simply not possible or advisable to provide a generic compensation scheme, given the complexity and differences of all the cases affected. It is for that very reason we are not making provision for a generic compensation scheme. However, stakeholders have made it clear in their statements and submissions to this committee and ourselves that they would like the Scottish Government to provide assurance that we fully understand the harm that this defect has caused and that compensation claims may arise as a result. I fully accept that in certain circumstances, correcting the legislative implications in this particular order may only be part of the route to giving satisfaction to those affected. However, for those who are affected by the order, we are providing £40,000 of funding towards mediation using independent and accredited mediators, because this is a real opportunity for reconciliation and for us all to move forward. And I would encourage all parties to take up the opportunity to work together and with the Scottish Government to establish the facts and the circumstances and explore all options for finding a solution, rather than simply finding yourselves putting more money into the pockets of lawyers than what might be necessary. Stakeholders have highlighted the importance of the Scottish Government being part of the mediation process, and where that is acceptable to both the tenant and the landlord, it is of course an approach which I will strongly support. We do of course have to look at each case and its merits, but given the circumstances, I would like to reassure those who believe they do have legitimate claims for compensation that I am not at this stage ruling out compensation or going down that road, but of course we need to look at each case on its merits. And of course I want to put on record that I am very sympathetic towards those people who have been harmed by this defect. There has been some confusion and anxiety around how absolute right to buy might affect some of the cases that have been caught with this defect. The key to this confusion is the distinction between secure 91 tenancies and 91 tenancies which are under limited partnerships. While limited partnerships are 91 tenancies, the key is that limited partnership 91 tenancies do not carry with them the security of being heritable tenancies. As the committee may recall, I am on record as having said back in September 2013, and I quote, that consideration of the absolute right to buy will be restricted to secure agricultural tenancies under the Agricultural Holdings Scotland Act 1991. Again, in November, I said that, and I quote, consideration will be limited to traditional secure 1991 agricultural tenancies. So I'd like to make it clear that those who have extended limited partnerships as part of a voluntary agreement or remain within limited partnerships 91 tenancies are not to be included within the scope of reviewing absolute right to buy and secure agricultural tenancies under the Agricultural Holdings Scotland Act 91. I accept that in Group 2 some tenants have ended up with a secure 91 tenancy. However, this outcome has been judged to be unlawful and is being addressed by the remedy. I would also like to provide assurance here that if the landlord does not convert secure 91 tenancies to unsecured tenancies, we will exempt those farms from the absolute right to buy if that measure is introduced as a result of the ongoing review of agricultural holdings legislation. So, to finish off, this has been an extremely complex legal case. I will no doubt be leaning on my colleagues on my left and my right to help me through this question and answer session, but I do hope that following questions that the committee will be able to agree with the comments from the Law Society that the draft order does the right things for the right reasons. Thank you.
Thank you, Cabinet Secretary. We welcome your statement, which helps with some of the questions that we do wish to ask you. But let's kick off with some of the ballpark situations. It's still been suggested by several people, including Richard Blake for Scottish Land and Estates, that some people may be aware but may not have come forward to identify themselves as they fear it may prejudice their position. In the evidence to the committee, stakeholders have suggested that some people affected by legislative defect haven't identified themselves as well. Therefore, they maybe have sold their farms or whatever. Is there anything further that the Scottish Government has done or can do to identify all those affected?
Thank you for the question. Clearly, when we received the court judgments, we realised we had a very difficult situation to deal with, which would affect the livelihoods and lives of a number of tenant farmers in Scotland and, of course, affect landlords as well. At the time of the bill going through Parliament in 2003, there was a lot of anecdotal evidence that perhaps, who knows, 300, at least several hundred, notices to quit were served to tenants with limited partnerships. However, we don't know how many notices were served, and clearly in 2013, now 2014, we've relied on the intelligence from the industry and all stakeholders to try and calculate, to the best of our ability, how many tenancies may have been affected. Clearly, we spoke to stakeholders, we publicised the fact that we wanted anyone who felt they'd been affected to get in touch with the Scottish Government, and we used all the usual channels to do that. And we, at the moment, have around 60 farmers who registered with the Scottish Government that they feel they'd been affected by this. And as you know from your previous session, we have whittled that down to around perhaps 20 or so farms or tenancies who face being directly affected now by where we are at the moment. So, on the positive side, we can take some comfort from the fact that we are relatively confident, speaking to stakeholders, and this is their view as well, that there are not hundreds of farmers affected, albeit we don't have an exact figure of how many are affected, but we feel we're now dealing with double figures as opposed to treble figures in terms of number of tenancies affected. So thankfully, perhaps the angst and the slight degree of panic we had when we received this court judgment has not come to fruition, and we have a better feel for how many people are actually affected. So I can't give the committee any guarantees about numbers. In terms of publicity for this issue, clearly this session, the ongoing media coverage that's been underway for the last year or so, hopefully has got the word out there that anyone who feels they're affected should get in touch with either their association, and then who in turn will get in touch with us, or directly contact the Scottish Government. So I'm relatively confident that most people who are seriously affected will be aware of what's happening.
Thank you for that. Turning to the treatment of groups 1 and 3 and ECHR compatibility, can you explain why the order provides different outcomes for the different identified groups, groups 1 and 2 to 3, 1, 2 and 3, both in terms of legal outcome and legal process?
Okay, I may ask colleagues to come in a second, but just the broad brush answer to your question is that we have painstakingly analysed those farmers and individuals, the landlords or tenants who've got in contact with the government to look at their individual circumstances. Because clearly, whilst on the one hand, the government wants to give certainty to tenants and landlords so we can move on from this. On the other hand, we want to protect the interests of those involved as well, and we don't want to needlessly upset people's businesses, and particularly in the case of tenants, have tenants who believe perhaps they were in a secure tenancy, suddenly finding out they're not, and all the turmoil that comes with that, going through needless change. So what we've looked at is very strictly the legal position of each of the different circumstances we are aware of, and then broken them down into the various groups that you've been discussing. And some groups are clearly much more affected than others. Some groups have moved on and circumstances have changed. And, you know, for instance, if a secure tenancy had come to an end through there being no one in place to inherit the tenancy, then that's basically out with the scope now of the remedy. Others, we have particularly Group 2 farmers, where we have a number of farmers who've been getting on with life on the understanding they're in secure tenancy, and then suddenly have had this bombshell of the court judgment. So Group 2 is clearly a group that's affected by this. And other groups are affected in different ways. So that's been the general approach to this. You know, I can give you the best estimate of numbers in each group. We reckon at Group 1, where the cases have yet to reach their termination date, we reckon there's a dozen farmers in that group. The assisted cases, Group 3, we reckon there's perhaps about 5 tenancies affected in that group. And likewise, Group 2, which I've just referred to, where are clearly cases affected, we reckon there's perhaps 5 or so cases in that group as well. So, you know, perhaps 20 overall are directly affected in one way or the other. I don't know if Paul wants to add anything just in terms of the...
I just may add one or two comments. I think the position in terms of how we've approached this is actually to try to secure, and we think we have secured, a consistent outcome for everybody affected. That is, that we felt it was appropriate to ensure that tenancies were converted to Section 73 circumstances. We've endeavoured to do that in a consistent way, not least because one of the criticisms of the court was because of an inconsistency that occurred before. So actually, for the 3 groups that are mainly affected by this order, they all end up in Section 73 circumstances. What happens is they get there by different routes, and that's where the different approaches appear. And the reason why they get there for different routes is because the circumstances are different. Group 3 is the most obvious different one because they're already in the court system. They're ongoing cases, and we felt it was appropriate for ongoing cases to be resolved by the Land Court. They're in the Land Court already, so the Land Court's the place in which we can get the Section 73 solution, not an order. For those who are affected because cases didn't get into court and affected already, that's Group 2, then there's a different solution to get to the same point. And equally in Group 1, where the solution date's not yet come, then again, it's different circumstances leading to different avenues to the same outcome. And we were comforted by the judgment of the Supreme Court when drawing out the inconsistent outcomes that were provided for in 2003, is they said that one of the problems for the landlords affected, such as Mr Salveson, was that he didn't get the benefit, that was the phrase the court used, didn't get the benefit of Section 73, which comforts us in our view that Section 73 is ECHR compliant as a solution, which we think it is. So the idea is to draw everybody into the same endpoint conclusion in a way that's consistent. And I'd simply to add one more point to that is, because of the way the section operated, there will be some leases that are already in Section 73 because of a notice served after 1st July 2003, which has led already to that situation arising. So the consistency applies to all circumstances.
Thank you for that helpful answer. Alec Ferguson to follow up on that point.
Thank you very much, Convener. In both written and oral evidence that the committee's heard, we've had concerns from all sides of this debate that ECHR compliance, if you like, is going to be extremely difficult to achieve in the round. From the answer you've given, can I just ask that you're confident that you'll be able to achieve that compliance?
Yes, we are confident that we are ECHR compliant.
If I could just go back to the basis of this whole problem, which was a Supreme Court judgment that, if I've got this right, effectively said that the human rights of a landlord had not been upheld, and therefore they'd been infringed. In light of that original judgment that is the cause of this whole problem and this whole issue, can the Cabinet Secretary give an assurance that the outcome of this will effectively be that affected landlords will be put back in the position that they were before this legislation was enacted in the first place?
Well, clearly the intention of the government is to put forward this remedy to address those cases that are unlawful according to Supreme judgments, and they will have to be made lawful. And that is our approach. We have policy intentions, which is to balance the interests of the tenants and the landlords as we take this forward. So clearly, because of the background where we have so many different circumstances that have occurred between 2003 and now, we can't put forward a proposal to reverse everything to pre-2003. So what we're doing is addressing what is unlawful to make it lawful.
I absolutely understand that. I've got a lot of sympathy with it as well. But can you do that, given the initial finding of the Supreme Court, can you effectively do that without being open to further challenge from a landlord or landlords?
Well, as I indicated, I'm not a lawyer and I'll ask colleagues to come in case I say anything's inaccurate from a legal perspective. But as indicated in my opening comments, the Supreme judgment was helpful in some ways in that it recognised the predicament that government would be in to address this issue and recognised a number of issues. So clearly we are reflecting what we see as the court judgment and have to address what is unlawful. And as I said before, I'm sorry to repeat the point, but just that it's obviously very complex, but we cannot turn the clock back to 2003 and create circumstances that were there before 2003. So what we have to do is address what's unlawful to make it lawful.
I do appreciate the complexity of all of this. Thank you.
Okay. Moving on through this system, Nigel Dawn.
Thank you, Convener, and good morning, gentlemen. I think I'm beginning to understand that as all the parties involved here started from a limited partnership, they all understood at the beginning that the landlord would get his land back, and therefore taking people through a Section 73 process, which eventually gives the landlord back, his land back, does sound perfectly reasonable. Except, and surely there can be an exception, and this has been pointed out to us, and these people would actually now be in Group 2, where, regardless of a misunderstanding of the law, the tenant may have been given, in good faith and possibly for value, a 1991 hereditable tenancy, which, as far as I can see, this order is actually going to take away from him. Now, you've previously said, if I understood you correctly, Cabinet Secretary, at the very beginning, that you think that's unlawful. I think I was quoting from your opening statement. But it's been suggested that it isn't, because it might be that the balance of the ECHR is actually with the tenant at that point. And that might be entirely consistent with the Supreme Court's intention. Now, could I, first of all, get your response to that as an assertion, at least, of a possibility, and then perhaps inquire what you feel the order might do about it? Please.
Well, clearly, notwithstanding the court judgment, which of course we have to address because of the unlawful aspects of the 2003 Act that have been highlighted, I have bent over backwards and we have worked painstakingly to exhaust all avenues to avoid being in a position clearly where a tenant in a secure tenancy would have to suddenly be in a much more uncertain position. As a policy intention, working within the law and to ensure that we address those elements that are unlawful, I've clearly wanted to protect the interests of tenants for obvious reasons, because we have a very unfortunate situation here where a tenant may have been living with the understanding they're in a secure tenancy and suddenly there's turmoil, potentially. But likewise, we have to balance the interests of the landlord and the tenant. So that's a difficult balancing act, as I said at the beginning. Therefore, that's why we are making this approach that we are making with the remedy, where there's a window of opportunity for the landlord to convert from Section 72 to 73. And that's because there's so many different circumstances out there. And I don't know the situation that exists between tenants and landlords in all those cases affected. However, the court judgment is there, and it did give a judgment on the ECHR aspects. Therefore, speculation or comments on anything else is difficult for us to refer to, because we have a court judgment that does just give us the view.
Would you accept that, at least in principle, what I've proposed might be right? Because I'm not a lawyer either. I mean, the last thing I want to do is second-guess what a court would say. And that it's just possible that one of those 5 cases, and I don't have an inside track on this, by the way, I don't have the information. It is just possible that one or many of those are folk who have actually acquired a hereditable 1991 tenancy in good faith and with the intention from the landlord that that is what he should have given. And the landlord is now in a position where the order will allow him to renege on that.
Well, this case only refers to those circumstances where the anti-avoidance measure was put into place. So we're talking about specific circumstances. We're not talking about other circumstances where the normal course of events may lead to the creation of secure tenancy. We're talking about specific circumstances, which was the anti-avoidance measures. So,
not disputing that, because clearly we're only referring to any case where notice was served in the time period. But I'm still picking up, and I accept this is potentially purely theoretical, but it might not just be purely theoretical, that the subsequent outcome of that might be hereditable 91 tenancy, potentially for value and at least in good faith by both parties. And we do run the risk, it seems to me, in this order of actually taking that away unnecessarily, when the balance of ECHR might say that the tenant should have it. And I guess the solution is, can we not allow, and we're only looking at 5 cases, the prospect somehow or other that might finish up in the Land Court, where that could be sorted out. And we come back to the basic point, the Land Court would be bound to come up with the ECHR compliant solution. So actually, if that was the right answer, it would give it.
I'll bring Paul in a second. I mean, a couple of comments I'd make in response to that finally before I hand over to Paul is, firstly, certainty. One plea we have had from tenants and landlords is for certainty. Can we get this fixed and give certainty? If we were to go down the route, potentially, and ultimately I guess it's up to the tenants and the landlords, of allowing cases to go back to Land Court and more uncertainty to continue over the same subject, then we're not answering the pleas for certainty from the tenants and landlords. So, you know, that's clearly a plea we've had from the industry. And clearly the final point I'd make is you did refer to in good faith by both parties. Well, if that relationship exists today, then that can continue. There's nothing in this remedy that's saying they have to change. The landlord has the opportunity to continue with the secure tenancy by not converting. What we're doing with the remedy is providing a means by which the unlawfulness, if that's a word, of the legislation can be fixed. However, if the tenant and the landlord want to continue with the secure tenancy, there's nothing preventing that happening if, as you say, both sides were happy with that and did it in good faith. Is there any further?
I just add to that. First of all, it's a theoretical possibility rather than one that we might know about. We know there's only 5 cases. We don't know if that arises. But really what I just say is that's the main reason why there's an opt-in conversion that makes the landlord choose and take the active positive step. It's not an onerous step, as has been suggested before. It's an active step in order to convert. Because in that hypothetical example, if actually the landlord is acting in bad faith, because they did come to a deal to allow that tenancy to arise, and still converts, then the landlord's then in a position where they're vulnerable to a position where the tenant can say, actually, we came to a deal in all of this, you've gone back on that deal. They may well have legal compensation at the end of the tenancy and could well have a claim for unjust enrichment against the landlord, or possibly breach of contract against the landlord for having done so. So the landlord has to think very carefully. Your question is predicated, as Cabinet Secretary says, it's predicated on good faith. Your question actually, put in that sense, suggests the landlord's not in good faith and has to take advice, I think, as to whether they want to take that step of converting, if actually that would go back on a deal that they'd come to with the tenant before and leaves themselves vulnerable. And I hope that landlords wouldn't do that, because we're in a position where we're trying to move towards the mediation and the cooling off period that involves a positive, forward-looking relationships that can help restore confidence in the sector, and the mediation process would certainly not be helped if, for example, there was a risk of further litigation around a landlord behaving in that kind of way. So we would hope that situation would be inconsistent with the general intention and their own legal liabilities to make things work in a positive way for the future.
Excuse me a second, Mr. Don. I think on that point, if it's not taking it forward, if it's on that point.
You know, it's broader, but it's within the context of that point.
All
do you
right,
want me
and
to
then we'll come back
wait?
to Nigel Don then after that.
Yeah.
Claudia
Oh,
Brunish.
thank you. Right. Sorry. Good morning, Cabinet Secretary. You've highlighted, both in your opening remarks and in response to questions, the need to protect the interests of tenants and obviously to find the balance of interests in relation to the remedial order. Can I just more broadly ask you about the public interest in relation to ECHR and whether the government could, and I just wanted this on the record at this late stage, if you don't mind, if you'll bear with me, whether the government could have opted to leave tenants in possession and pay compensation to landlords in relation to the public interest argument. And why has that argument never been made for the secure tenancy of the limited partnership tenants? Could you perhaps clarify that for me?
Well, I hope I've conveyed to the committee that we have bent over backwards and left no stone unturned in a bid to ensure we are supporting a vibrant tenancy sector in Scotland, and therefore it's not in our interest to see tenant farmers tuffed off their farms because of something that was decided back in 2003, which was found out to be unlawful. However, we do have a legal framework in place. This has been exhausted right throughout the legal process to the Supreme Court, and the issue that you've just mentioned was looked at, as I understand it, as part of the court's deliberations. And now we have the judgment, and therefore we have an unlawful situation that has to be made lawful. And unfortunately, that's just where we are. But I do believe, because of our approach to this, we are hopefully going to minimise disruption in comparison to what it may have otherwise been, given the chosen route we're going down. And as I said before, given the starting point was that we felt there was potentially going to be hundreds of tenancies affected, we're now in a position with the route we're taking, and obviously in mediation as part of that, that hopefully, you know, we will at one end perhaps be as high as double figures, but who knows, we may get into single figures. We don't know in terms of who are actually directly affected. So that's been our approach to this.
Okay. And back to Nigel Don.
Yeah, thank you, Convener. I'm just, can I go back to that previous point and just explore whether what I'm hypothesising, and I accept that this may be theoretical because I genuinely don't know whether there's a tenant out there in this position, but it seems to me that it's perfectly possible that there is a tenant whose interest in retaining what they currently have as a hereditable 91 tenancy might be substantial and might leave to the next Salveson and Riddle, because there's nothing we can do in this order which prevents ourselves from being taken back to court. And the argument would be ECHR, and it would be that this order didn't adequately balance the tenant's rights with that of the landlord. Could I ask you merely to reflect on whether it might be sensible to put something in the order that does at least open up the possibility of these folk being able to finish up in the land court rather more swiftly and rather more cheaply for all involved, if that were to look like the right answer? And I am conscious, as I say that we are talking about a handful of potential cases, and probably no more than one or two in reality, if there are any at all. I wonder if I could just leave that with you as a thought, because I wouldn't want to be the author of the next Salveson and Riddle when we could see it coming. I just also wonder, given that it's a question we were going to get to a bit later, whether there's anything more that needs to be said about the opt-in and opt-out. I think Bukakit's just commented that on that. I'm just wondering whether there's anything else that we ought to be aware of. I'm wondering whether there's an ECHR argument about that, as well as the idea that it forces the landlord to think.
Well, again, we have chosen what we feel is an appropriate route to fix the unlawfulness of the 2003 Act, and we have policy intentions, which I've explained to you, so we feel this is the most proportionate way forward that helps hopefully minimise disruption for both parties in terms of giving a cooling off period for mediation, and then there's a window of opportunity for landlords to convert thereafter, and we feel that's a reasonable way forwards. And we'll reflect on your other comment.
Thanks very much.
Okay. In that case, what's your view of the issues raised by the STFA, that proposals for dealing with groups 1 and 2 should be revisited in the light of what Nigel Dawn has said, and just to make it clear for the rest of us?
Well, I guess that just comes back to the fact that we have identified various groups of circumstances, some of which are in an unlawful position at the moment, and some of which are in different circumstances. Therefore, I mean, I'm not sure what else I can say to answer that question, if Paul wants to come in. And
there's nothing really more I'd add. The only thing I'd say is that one of the suggestions of looking at the way that ongoing the assisted cases are allowed to continue to the Land Court should be applied across the board. And in one sense, that would have been an easy option for us to say, this is all too difficult. We'll pass everything over to the Land Court and then you sort it out. But I don't think that would have been an acceptable solution for a government to take to address this sort of issue. And it's certainly not desirable to encourage more litigation, as the Cabinet Secretary has said. So the solution we've tended to adopt is where cases are in court already, they have to be dealt with in court, but we don't really want cases to end up in court that don't have to, which is why we've taken a different approach, and that does lead to the differential avenues to hopefully, as I say, the same outcome.
Thank you for that clarification. But looking at assisted cases now, Jim Hume.
Thank you very much, Convener, and good morning, Cabinet Secretary. Just looking at Section 3 of the proposed draft order, those in Group 3, the assisted cases are to be treated differently than those in Group 2. In particular, the landlord in Group 2 has to opt into Section 73, whereas in Group 3, the assisted cases, it's just automatic that the Section 73 will apply. I just wondering what's the rationale between the differences between those two groups?
Again, there's no practical difference in the outcome that Section 73 will apply. What Article 3 does is, because the cases are in the court, and it was suggested, I think, by one of the witnesses, that what the government wants parties to do is get out the court process. Actually, our view is the other way around. We'd far rather people completed the court processes that are within the Land Court. The court has to resolve the cases before it. But what Article 3 is intended to do is to achieve the Section 73 outcome, but gives the court maximum flexibility in determining the cases that are with it already. And it can allow it, for example, if a landlord wishes to shorten the notice period in Section 73, it can do so by combining those within one court action. So you've got one court action rather than two court actions, which is obviously beneficial. We also have given a power to make changes to the termination date, but that's only to give the Land Court the flexibility to ensure that on any disposal of the case, it does so in a way that's ECHR compliant, because the Land Court itself is a body that requires to make decisions that are consistent and compatible with ECHR, and this ensures that they have the option to do so.
Okay. Just to further go on that point about some of the differences, another difference regarding those two groups is in Section In Group 2, it says in the interim the tenant will have a secure 1991 Act in his own right, including the preemptive right to buy, whereas that's not the case in Group 3. Some of the evidence that we held, or heard I should say, was the opposite of that, and said that that could be at odds with the UK Supreme Court ruling, and it could allow the court to grant the tenant a secure 1991 Act tenancy for assisted cases. So there's a bit confusion there. So I would like clarification on that, and or perhaps would there be a consideration to amend the order to reduce some confusion and any ambiguity?
One thing I could perhaps say is it's clearly our view that it's not open to the Land Court to decide cases before it to give the outcome that was outlawed by the Supreme Court. The Land Court has to have regard to the jurisprudence of ECHR, and that includes the judgment of Salvesen and Riddle. So one of the options that's not open to it would be to do something that would be inconsistent with the decision of Salvesen and Riddle.
Thanks. Yep.
Okay. Angus MacDonald.
Thanks, Convener. Good morning, Cabinet Secretary. As we know, the draft order proposes a legal remedy for Groups 1 to 3, but not for Groups 4 to 5. And we also know that, in the Government's view, Groups 4 to 5 have gone beyond the scope of the Act and the order. However, we've actually heard a range of views from stakeholders as to whether Groups 4 and 5 should be included or excluded, and in particular, Scottish Land and Estates have expressed concern that those in Groups 4 and 5 have not been fully or adequately treated in the proposed draft order, and they are questioning whether excluding Group 4 from the legal remedy in the draft order is fully compliant with ECHR obligations. Can I ask, how do you respond to these concerns raised by Scottish Land and Estates and other stakeholders about the exclusion of Groups 4 and 5 from the proposed draft order, and how do you propose to work with people in Groups 4 and 5 who wish to seek redress?
Well, clearly we'll work with anyone who approaches us because, as I said before, we are looking at individual circumstances across the board. However, when this case arose initially, clearly I was thinking about how to handle it, and I thought of my different options, and one way would have just been simply put through an order to identify all those people affected and then just, convert from a Section 72 to 73, and just, that's it, done, dusted. I didn't take that attitude because I realised that we wanted to help people, and we didn't want to have more disruption than was absolutely required to the tenancy sector in particular because of the circumstances outlined before. But of course I had to strike that balance between the landlord and the tenant in terms of legality. So that's why we broke down those cases we were aware of into individual circumstances and took a view that no, we are going to look at individual circumstances, we're going to try and address each individual circumstance, and where we feel that those circumstances have moved beyond the scope of any remedy, they would be in a separate group. Because, if a farm has been sold, if there was a mutual agreement in some circumstances between the tenant and the landlord over the next stage of that tenancy, because there was no heirs in place or because the tenant passed away or whatever it may be, these cases have just simply moved on, and we didn't want to intervene needlessly in those cases. So that's just the sort of approach we took, which I think has been the right approach and the most helpful approach to those directly affected by this judgment. I don't know if there's any legal points to bring in.
Just two other further observations, one of which is just to echo what the Cabinet Secretary said. Group 4 and Group 5 are different. They're beyond the scope of the order effectively in two different ways. Group 4, as has been said, are circumstances where they're beyond the scope because this order seeks to convert in one form or other existing tenancies into Section 73. But if intervening events between 2003 and now have meant there is no tenancy to convert, then the order can't convert them. So they fall out of the scope for that reason. And therefore, the remedy here doesn't address those. That's not to say there aren't remedies, but this order is designed to ensure that the legislation that affects tenancies is brought into ECHR compatibility. So that's the reason why those groups are not addressed specifically in this order. For Group 5, which are effectively sometimes described as bilateral agreements. Their circumstances where the landlord and tenant came to an agreement in some form or other, no doubt in the shadow of Section 72, no doubt influenced by Section 72 and impacted by that, but the outcomes they came to are not a direct consequence of the operation of law. It's a direct consequence of the bilateral agreement they entered into with each other. And in that sense, therefore, changing what Section 72 provides is a different issue from the bilateral agreements that fall out with that.
Okay, so should an issue arise with either Section Group 4 or Group 5, their course of action would be presumably through the Land Court?
Not necessarily, certainly through a court, not necessarily through the Land Court. They probably wouldn't get to the Land Court, but if you had a bilateral agreement that has been entered into, and you then decide actually that you wish you hadn't entered into that agreement, and you perhaps did so, because of mistake of an understanding of the law, which Mr. Salverson's case has clarified, then those parties will have to take their own advice as to what their options are. But it was those parties who entered into the agreement with each other who did that, and the remedies they would look to take would be dependent on the advice they got at the time and the advice they get now as to what to do about that. This order isn't the place to deal with that sort of circumstances.
Thank you.
Body of Beamish on that point.
Convener. Cabinet Secretary, could I ask you, although I'm listening carefully to the answers that have been given by yourself and your colleagues on Group 5, could I ask you, though, there is still concern around that, although it's with the order, and I wonder if I could seek any clarification on the position of the Riddle family, particularly from a legal perspective. Although Andrew Riddle, as we all know, sadly deceased now, is regarded as having settled his dispute with Salverson out of court by not pursuing it any further, this does fall into Group 5. And would the Cabinet Secretary agree with me that morally, if anyone deserves compensation, it is possibly the Riddle family?
Well, clearly,
I appreciate it's difficult to comment on a case, but I sort of want to put on the record. Sorry to interrupt you. But,
okay. Well, clearly, I can only say that the very difficult circumstances of that case we're all aware of, and I cannot comment on the legalities of individual cases. Therefore, any family or individual affected is, of course, free to take their own legal advice or speak to their own associations for advice. And we will engage with anyone who wants to speak to government about any particular case. We can't give legal advice, of course, to individual tenants or their families, but in terms of the wider issues, clearly we will engage with anyone.
On to mediation and cooling off. Cara Hilton? No, you're not going to do anything? Okay, you don't want to raise any points in that. Graham Day.
Thank you. Good morning, Cabinet Secretary. I think your opening comments on mediation were helpful in clarifying the government's position. But can I ask one or two small questions? Will the offer of mediation, which you've talked about being available to when the landowner and the tenant would both want the government to be involved, so would the offer of mediation be open only to those in Group 2 or other of the affected groups? What informed the setting of a £40,000 ceiling on funding for mediation? And when you refer to independent mediators, can you expand upon the definition of independent? Would you envisage it being people with an industry background, a legal background, or would it be those who offer more general mediation services?
Firstly, I do hope that landlords and tenants affected will go down the mediation routes if they're unable to immediately reach an agreement amongst themselves. And I would urge them to do so. And that would be a much more helpful way forward for all parties and for tenant farming in Scotland. In terms of the mediation itself, of course, there are accredited professional mediators, and in conjunction with stakeholders, we've identified who that would be, and these are the people who will be employed at the government's expense. And I'm willing to make resource available for that. The £40,000 figure that I gave the committee is simply an estimate of what may be required I don't have a ceiling on it per se. Clearly, we have to pay attention to resources, and I'm not saying there's a limitless pot available, but, you know, if it goes above £40,000, we'll cover that as well. That's not a fixed ceiling, that's simply an estimate of how much we think we may have to allocate for mediation. It'll all depend on the demand, won't it? Because, as you said yourself, for it to work, we need both the tenant and the landlord to come to the table.
Yeah, and to be clear, the mediation route, would it be available to everybody who's been affected by the defect or just those in Group 2?
Apologies, I didn't answer that point. Yes, that is the case. We'll make that available to any of the key cases affected, irrespective of which group.
Jim. Thanks. Just on the point of that 40,000, you announced the 40,000 as though that was almost like a grant thing, but I think you've just clarified that that's just an estimation of what that cost would be. I would like just a double clarification of that, because it seemed a wee bit at odds. And also, is that an estimation or an amount per case, or is it per individual organisation, landlord, tenant, for example?
The £40,000 is simply the resource we're allocating at this stage for mediation. If it appears there's greater demand for mediation and even more landlords and tenants agree to come forward to participate than we expect, we'll make the additional resource available at that point.
And just to clarify my other point, is that 40,000 allocated from government funds at the moment per case then, or is it per tenant?
The budget. We will engage mediation services.
For all mediation?
Yes.
Right, okay. Thanks. So much.
The subject of compensation, Claudia Beamish is going to...
The convener. Cabinet Secretary, you've in your opening remarks, you have already made comment about compensation, but I hope you'll bear with me if I highlight some of the evidence that came before us, as this is obviously a key aspect of the settlement in the fairest possible way for everyone concerned. And then there's one or two questions I'd like to ask, and possibly others will want to follow up from them. The proposed order and the supporting documents do not include reference, as you know, to compensation. But given that farm sales and bilateral agreements have been made, compensation is, in many cases, could be significant. And in evidence to the committee, David Barhari, if you don't mind me quoting from previously, has said that we have to be absolutely clear to everybody all along that if they feel that harm has been caused to them, they make claims against the Scottish Government. Those claims will be looked at in the context of the merits of each case. There is an awareness of the issue, but there is a great difficulty in generically accepting liability. And then Scott Walker from NFUS said, the key point is that the government, that was in evidence to us as well, the key point is that the government must be open to negotiating with individuals. It must send out the clear message that it accepts that there will be compensation and that liability will land at its door. The government's attitude in progressing such cases will matter. The government should not take a legal attitude of whittling down every claim down to the lowest possible amount. Now, I'm not necessarily associating myself with those remarks, but I think that we need that perhaps out in the open today, that there is a concern that might happen. And Richard Blake stated in oral evidence, I share Angus McCall's view that a statement from the government is needed to provide clarity. Yourself, Cabinet Secretary, I think has acknowledged today that there will be compensation cases, and that's quite clear to people who've been financially or personally disadvantaged by the legal defect and the proposed remedy. But could I ask you, although stakeholders in giving evidence to us generally accepted that the generic compensation scheme should not be included in the order, could I ask whether the Scottish Government might be in a position to state its position on compensation in relation to all affected parties? And would you be able to put your position on this within the order? Could there be mention of such a scheme, though no detail, within the order itself, to reassure people?
Firstly, as I said previously, the government's approach will be both sympathetic and responsible. And I am not ruling out compensation, and there may well be some circumstances in which compensation is justified. But clearly we're at a stage just now where we are looking at the circumstances of many different cases. We wish the parties to consider mediation as the best route to reach a settlement, and hopefully some circumstances will arise where there's no need for any further intervention from government if parties can reach their own agreements. And that's by far and away the best way forward for hopefully most of the cases. However, as I said before, there may well be cases where compensation is a very valid option, and we'll leave that on the table. I don't think there's actually any need for that to be in the order. The order is about correcting an unlawful aspect of the legislation, and that's the purpose of the order. But in terms of government policy, I'm making it clear to the committee today that there may be circumstances where compensation is an option. We'll leave that on the table. We're certainly not ruling it out.
Could I just come back on that and ask you, just push you a little bit on that, about the reassurance that putting something about compensation possibly being the route that some people might have to go down, whether it wouldn't be reassuring for people to have that in the order?
The reassurance I'm trying to give the committee today is I do recognise there are some circumstances that could arise where compensation is justified, and for that reason we do see that as a valid option. But clearly, without understanding all the circumstances and what the outcome of mediation may be, we are unable to put any more meat in the bones in terms of the compensation issue. I think the fact that both the stakeholders and the government, and hopefully the committee, agree there should not be a generic compensation scheme is a good thing, because we all recognise the circumstances here.
Graham Day.
Thank you. Continuing the compensation theme, Cabinet Secretary, I recognise it's a difficult question perhaps to answer, but apart from offering to fund and facilitate mediation, how can we avoid a situation where resolving these cases doesn't become a drawn-out affair which provides rich pickings for the lawyers?
Well, that's why I'm approaching the subject cautiously, but recognising there could be circumstances where compensation would be a perfectly valid outcome. And there are so many different circumstances out there. And I think clearly there will be many circumstances where there's no case for compensation, but there may well, as I've just said, be some cases where compensation is a valid option. And that's why we're not going down the route of a generic compensation scheme. However, we have to leave our options open until we understand the circumstances of all the different complex cases out there.
Richard Lyle, does that answer your point?
Yeah, on that point, Cabinet Secretary, good morning. I welcome your statement about the 40,000. I welcome your statement about you want mediation, and I certainly agree with that and made the comments on that a couple of weeks ago. When people went for PPI, they didn't need to go to court. They basically went to the bank and said, "You've overcharged me, can I have my money back, please?" If people come to the government and say, "You've cost me money, can I have my money, please?" will they need to take you to court?
Well, as I've said already, I think we've taken a very sensible approach to these cases. We have indicated we're willing to discuss with all the parties affected the individual circumstances. I think the last thing that we want to encourage is more cash getting into the pockets of lawyers, which is a comment I've already made, and clearly if we were to go down the route that you suggest, that would do that. So we want to avoid that, and clearly we just want all parties to be sensible about this. No one wants to be where we are at the moment with this judgment, but we have to deal with it, and we have to deal with it in the most sensible and responsible way we can.
Jim Hume.
Just following on from Graham Day's point about the mediation, and it's been mentioned before, but your estimation of helping with mediation, which would be fantastic, of course, and your £40,000 that you mentioned, would that be seeing yourselves as fully funding mediation, or would you be sort of funding a certain percentage of the mediation? Could you?
Well, at this point, we're happy to fund the mediation. We've said to the sectors that we've been speaking to that we are keen on the mediation route, and therefore we're willing to fund that.
Fully fund?
Yes.
Yes. Okay, thanks. Yeah.
Clearly, if for some reason it ran into millions of pounds in the future, we'd have to reconsider. No, yes. But we're not anticipating that, and we've said we'll fully fund the mediation as part of trying to get a solution.
Thanks. No, that's useful. Thank you.
Okay, going on from there, you have a question, I think.
Much, Convener. It's just going on to the situation of time barring. We've had various opinions. One on groups 4 and 5. One opinion was that a time bar could start at the date of the Supreme Court judgment. Others thought that it could start at the date of enactment of the legislation. And we also had an opinion that because of the confusion, it may be useful to add to the draft order a provision for time barring that is specific to the various situations. It would be interesting to hear what your understanding of the position with regarding to time bar was for as a result of this order.
Well, I mean, our view is that there's no need for any special arrangements in relation to time bars, but I'm happy to ask colleagues in terms of the legal dimension of that.
Yeah, and one of the things we're conscious of in the order is that out with the specific provisions, there are common law and statutory structures and frameworks within which remedies can be secured. One of those relates to the law in relation to time bar, and within the Prescription and Limitation Act, there's a power for a court in dealing with a time bar case where it's equitable, is the phrase that's used in the legislation, to disapply time bar on the facts and circumstances applying in the particular case. And our view is that that's the appropriate place for a court to decide if a time bar issue were to arise as to whether a case is time barred or is not. That a specific provision in this case would obviously could only be of a general application and wouldn't really assist in individual circumstances. So our view is that suspension of time bar as a general proposition is not necessary or appropriate in relation to this particular remedy.
Okay, and therefore you think that anybody in, well, any of the groups, but 4 or 5 or any of the other groups won't have to face a time bar at all then, or?
If they could show to the court that there's good reasons why they haven't raised the case in time, yes, they'll be in that position.
So it has to be in their powers to, it has to be in their responsibility rather than
advice as to the way forward and act accordingly.
So you don't, have you considered, as suggested by some from the Law Society, I think it was, to actually add a draft order just to give that reassurance rather than them having to make a case for?
We didn't think it was sensible to make a general application because there could be circumstances where it wouldn't be appropriate to extend the time bar period.
Mm-hmm. Okay, thanks.
Alec Ferguson.
Thank you, Convener. I just want to seek absolute clarity on this issue because there was a bit of confusion about it, I think, at our last meeting as to whether the time bar, if it came into play, if that's correct expression, would be the traditional 5-year time bar or for legal challenges, or whether it would be 1 year, as was suggested perhaps at our last meeting. And I wonder if you could clarify that for us.
I don't know the individual basis in which it might be suggested that the 1 year time bar would apply, and obviously I can't give advice to the committee on that aspect. I would certainly have thought the 5-year time bar would be the period that would apply, but again, it's not something I've looked at specifically as to what that period would be, and I'm not sure I'm in a position to advise the committee definitively.
With great respect, I wonder if that could be looked at and you could provide an answer to the committee, because I think it's quite important.
Yeah. We'll take that away and bring it back to the committee with our views.
Yeah, I'd be grateful for that. Thank you. Thank you.
That's fine. Okay, members happy with those questions so far and the answers? We're very happy to receive. I'd like to thank the Cabinet Secretary and his officials for this complicated matter. Take it forward, and indeed we will now end this particular session. Thank you. At our next meeting on the 29th of January, we'll hold evidence session with stakeholders on NPF3 and consider a report on this draft Agricultural Holdings Scotland Act 2003 Remedial Order 2014. And with that, we'll end the formal part of the meeting, go into private and clear the public gallery.